This podcast is intended for informational purposes only and should not be considered or interpreted as legal or professional advice.
Welcome to another episode of Mika Minutes. I'm your host, Mika Domingo. What do you do when you're a conservator? This episode focuses on general conservatorships, as those are the most common type of conservatorships. If you are interested in the process of applying for a conservatorship, check out our previous episode on how do you become a conservator. Once you are appointed conservator, you will receive a letters of conservatorship from the court, which you will need to file and keep as proof of your appointment. You'll use the letters to show financial institutions, for example, to help you open a bank account for the conservatorship. If you haven't already done so, be sure to complete your conservatorship orientation class, which is an educational program provided by either your local court, university, or community college. You'll need to fill out and file the certificate of completion. You may also need to get a bond if your case requires it. A bond is a type of insurance. You'll sign an agreement with a bond company that ensures that you, as a conservator, will faithfully perform your duties required by the court, and that failure to do so will require you to pay some type of penalty. Because conservators are given partial or full authority over someone, the court may require a conservator to have this bond to protect the conservatee and their estate. If you're managing your conservatee's estate, conservators will need to marshal all the assets and property the conservatee owns and take steps to mitigate any loss or damage to them. Conservators must keep their money separate from the conservatee's assets, show the title of all the conservatee's financial assets and personal property belongs with the conservatorship's estate, and get approval from the court prior to reimbursing themselves for any services made or any money that's borrowed in order to administer the person's estate. Conservators of an estate must open an estate checking account at a local bank and transfer the conservatee's assets into this account. Conservators may make investments without court approval if the investments will meet the conservatee's needs, but conservators can't make risky investments. There may be times when a conservator has to sell the conservatee's house in order to use the proceeds from the sale to finance the conservatee's needs. Making a budget and sticking to it will be vital to ensure the estate has enough funds to provide for the conservatee and to pay for the bills and any expenses. Conservators will need to prepare an inventory and appraisal, listing the real and personal property of the conservatee's estate and the value of those assets. Conservators must provide an accounting to the court and the conservatee about their management of the conservatee's assets. To prepare for the required accounting, you should maintain an itemized list of each financial transaction affecting the estate. An estate is a separate taxpayer for federal and state income tax purposes. Conservators must file income tax returns on behalf of the conservatee. In my next episode, I will be discussing conservatorship of the person and how to end conservatorships. Stay tuned.